The grand federal courthouse in Washington, D.C. buzzed with anticipation. Rows of legal experts, journalists, and curious onlookers filled the gallery, eager to witness what many assumed would be a routine legal proceeding. At the center of it all sat Judge Richard Callaway, a man known for his sharp legal mind and unwavering intolerance for theatrics. Having presided over some of the most complex cases in the country, he had little patience for those who thought fame or wealth could sway the scales of justice. But today was different. Today, the courtroom's focus was not on a seasoned attorney or a high-profile defendant. Instead, standing at the defendant's podium was Barron Trump, the 18-year-old son of the recently re-elected President of the United States, Donald Trump. Dressed in a perfectly tailored navy blue suit, he stood with an air of quiet confidence, his hands folded in front of him. The moment Judge Callaway glanced at the case file and saw Barron's name, a smirk tugged at the corner of his lips. He leaned back in his chair, tapping his gavel lightly against the bench, before addressing the young man before him. "Mr. Trump," he said, his tone laced with skepticism, "this is a first for me, an 18-year-old standing before this court expecting to argue a case. Now, I understand your last name opens doors, but the courtroom isn't one of them." A ripple of laughter spread through the spectators. A few attorneys exchanged amused glances, whispering to one another. Even the opposing counsel, Martin Holloway, an accomplished litigator with over 25 years of experience, smirked as he adjusted his tie. All eyes turned to Barron, expecting to see him flustered, embarrassed, perhaps even retreating into nervous silence. Instead, he remained still, unshaken, his gaze fixed on the judge. No fidgeting, no awkward shifting, no sign of unease. Judge Callaway raised an eyebrow. "Nothing to say? No grand speech prepared?" he asked, half amused. Finally, Barron spoke. His voice was steady, not loud but filled with conviction. "I wasn't aware the purpose of this court was entertainment, Your Honor." The laughter died instantly. The room, which had moments ago been filled with quiet murmurs and amused whispers, fell into complete silence. Even the judge's smirk flickered, barely noticeable, but it was there. For the first time that afternoon, the tone of the courtroom had shifted. A tense silence filled the courtroom. The smirks had vanished, replaced by furrowed brows and exchanged glances among the legal professionals present. Judge Callaway, who had been moments away from dismissing Barron Trump as just another privileged young man playing lawyer, now found himself studying the 18-year-old more closely. There was no hesitation in Barron's stance, no sign of nervousness, only a quiet confidence that didn't seem rehearsed. The judge leaned forward slightly, interlacing his fingers. "Well," he mused, flipping through the case file before him, "let's hope you can back up that confidence with something other than your last name." The tension in the room became palpable. Up until this moment, the expectation had been clear. Barron would stumble over legal jargon, fluster under pressure, and ultimately serve as nothing more than an amusing anecdote about why law should be left to professionals. But now doubt crept into that certainty. Martin Holloway, the opposing counsel, cleared his throat and stepped forward. He was a man used to dismantling weak arguments with ease, a veteran of high-profile cases who had debated in front of Supreme Court justices. Facing off against an 18-year-old should have been effortless, and yet something about the way Barron Trump stood, poised and completely unshaken, made him pause. "Still," Holloway smirked, adjusting his tie. "Your Honor," he said smoothly, "with all due respect, we're not here for a law school debate. The facts of this case remain unchanged, and no amount of confidence from Mr. Trump will alter that." Barron tilted his head slightly, his expression unreadable. "If the facts are so clear, then why is your argument already shifting?" A low murmur rippled through the gallery. Even some of the seasoned attorneys sitting in the audience leaned forward slightly, intrigued. Holloway's smirk faltered. "Excuse me?" Barron stepped forward, placing a neatly organized stack of legal documents on the podium. He flipped open the first page with measured precision, as if he had done this 100 times before. His voice was calm, even, but there was a quiet edge to it, one that commanded attention. Before we proceed, Barron said, adjusting the microphone, I'd like to clarify a few legal misinterpretations that have already been presented in this case. The gallery fell completely silent. Pens that had been scribbling notes now hovered motionless above paper. Even the journalists, who had expected to be writing about a political dynasty's overreach, suddenly realized they might be covering something entirely different. Barron continued, his voice steady. The opposing counsel has repeatedly cited Keating v. Burlington as justification for dismissing critical evidence in this case. However, that ruling explicitly stated that procedural errors must directly impact the reliability of said evidence. In this instance, that standard has not been met. Holloway frowned, flipping through his own notes. Judge Calloway raised an eyebrow. That's a bold claim, Mr. Trump. It's not a claim, Your Honor, Barron countered smoothly. It's precedent. Another murmur from the audience. The judge exhaled sharply, tapping his pen against the bench. Let me get this straight. You're arguing that the opposition's interpretation of Keating v. Burlington is incorrect. Not incorrect, Barron corrected. Selective. A quiet but audible gasp came from one of the younger attorneys seated behind Holloway's table. The veteran litigator tightened his jaw, quickly trying to recalibrate. This was not going as planned. Barron flipped another page in his brief. Furthermore, if we're discussing admissibility, then Foster v. Crane is the more appropriate precedent, as it directly addresses testimonial credibility under indirect coercion. That ruling sets a clear standard for when evidence can be dismissed, and the circumstances of this case do not meet those conditions. A flicker of movement, Holloway's hand tightening around the edge of the table. He scanned his notes, looking for a rebuttal, but Barron had struck first. Judge Calloway leaned back, studying Barron with newfound interest. "Counselor," he said, turning to Holloway, "would you like to respond to that?" Holloway hesitated, a fraction of a second too long. Then finally he cleared his throat. "I will address that in my argument, Your Honor. It was a retreat, plain and simple. The gallery knew it. The judge knew it. The journalists definitely knew it. And Barron? He simply adjusted his papers, waiting for the next move. Judge Calloway tapped his pen on the bench. The amusement from earlier had faded completely, replaced by something else. Curiosity. "All right, Mr. Trump," he said, his tone more measured than before. "Continue." But now, it wasn't just about continuing, it was about proving this wasn't a fluke. And the entire courtroom, Judge Calloway, Martin Holloway, the journalists, the attorneys, were all waiting for Barron's next move, hanging on his every word. The air in the courtroom was thick with tension. What had begun as an anticipated spectacle, an 18-year-old being humiliated by a seasoned litigator, had now transformed into something entirely different. Barron Trump, standing firm behind the podium, had not only held his ground, but had begun systematically dismantling the opposition's case piece by piece. Across the room, Martin Holloway, the veteran attorney who had once seemed so self-assured, was no longer smirking. His polished confidence had cracked, his fingers gripping the edge of his notes just a little too tightly. Judge Calloway tapped his pen against his desk, his previously condescending tone now measured. "Mr. Trump," he said, leaning forward slightly, "I have to admit, I wasn't expecting this level of preparation from you." Barron, as composed as ever, inclined his head slightly but didn't gloat. "I came prepared, Your Honor. Nothing more." A ripple of murmurs spread through the gallery. Attorneys whispering to one another, journalists frantically typing, trying to keep up with the unexpected turn of events. Holloway, unwilling to let an 18-year-old outmaneuver him, adjusted his tie and stepped forward. "Your Honor," he said, regaining some of his composure, "while Mr. Trump's reference to Foster v. Crane is certainly impressive, it does not hold weight in this particular context. That case was about testimonial coercion, not the chain of evidence." Barron didn't hesitate. He flipped another page in his notes, lifting it slightly. "Actually, counsel is mistaken," he said, his voice unwavering. "The ruling in Foster didn't just address coercion. It reinforced that testimony remains admissible if primary conditions of influence do not exist, which in this case, they do not. A slight intake of breath came from the back of the courtroom. Holloway stiffened. Judge Calloway raised an eyebrow. Barron continued, undeterred. Your Honor, the idea that testimony should be discarded simply because it presents an inconvenience to the opposing side is not just legally incorrect, it's dangerous. If we begin applying precedents selectively, we undermine the foundation of due process. Silence. Then the unmistakable sound of a reporter muttering, "Unbelievable," under his breath as he furiously typed. Judge Calloway exhaled through his nose, watching Barron carefully. "So, Mr. Trump," he said, his voice quieter now, "if we follow your interpretation, what exactly do you believe the court should do next?" The entire room seemed to hold its breath. Barron placed both hands on the podium and met the judge's gaze head-on. "Rule in favor of the testimony's admissibility," he said, his tone firm but respectful. "Anything less would be a deviation from the established legal framework." A heavy pause filled the room. Holloway, lips pressed into a thin line, flipped through his notes, searching desperately for a counter-argument. But there was nothing. No loophole, no technicality he could exploit. He had underestimated the boy standing before him, and now he was paying for it. The judge let the silence linger, allowing the weight of the moment to settle over the courtroom. Finally, he turned to Holloway. "Counselor," he said, "do you have anything to say in response?" Holloway's jaw tightened. He glanced down at his notes, then at Barron, then back at his notes. Finally, after a long pause, he spoke through gritted teeth. "No further objections, Your Honor." A murmur spread through the gallery. It was over. Barron Trump, the 18-year-old they had laughed at just moments ago, had just forced one of the most respected litigators in the country into retreat. Judge Calloway drummed his fingers against his bench, studying Barron with an unreadable expression. Then, after a long moment, he nodded slowly. "In that case," he said, lifting his gavel, "the testimony remains admissible." Bang! The gavel struck. The tension that had been simmering in the courtroom finally broke. Some gasps, a few whispered exchanges, the unmistakable sound of someone scribbling notes at a furious pace. Barron exhaled slowly, not in relief but in quiet acknowledgement. He had known this was how it would end. Judge Calloway continued to watch him, but the skepticism from earlier was gone. In its place was something different. Respect, perhaps, but also realization. This wasn't just a well-rehearsed performance. This wasn't just a rich kid throwing around legal terms to sound impressive. This was a young man who had come prepared, and he had left the courtroom speechless. The courtroom was still. The weight of the moment hung in the air, pressing down on every person in the gallery. The once dismissive murmurs had turned into stunned silence. Barron Trump, the young man they had laughed at just an hour ago, now stood victorious. Judge Richard Calloway, a man who had built his career on skepticism and a deep distrust of high-profile figures, sat back in his chair, his fingers tapping rhythmically against the bench. His eyes lingered on Barron, as if reassessing everything he had previously assumed. "Mr. Trump," he said, his voice quieter now, lacking its earlier sarcasm, "do you realize what you've just done?" Barron, still composed, met the judge's gaze. His response was simple. "I presented the only legally consistent conclusion, Your Honor." A soft chuckle escaped from one of the reporters in the front row, not out of ridicule but out of pure disbelief. The seasoned journalists who had expected to write about the embarrassing courtroom misstep of a former president's son were now furiously reworking their headlines. Judge Calloway let out a long breath, his eyes shifting toward Martin Holloway, the opposing attorney, who had spent years mastering the art of legal argument. But in the face of Barron Trump's unshakable logic, even Holloway had been forced to retreat. "Counselor," the judge said, addressing Holloway, "do you have anything further to add?" The tension in the room tightened as all eyes turned to the veteran lawyer. Holloway's jaw clenched. his fingers gripping the edges of his notes as if there was anything he could use to salvage the case. He flipped a page, then another, but it was a meaningless effort. There was nothing left to argue. After a long pause, he slowly closed his folder. "No further objections, Your Honor." The gallery erupted in whispers, some gasps, some hurried exchanges between attorneys who had just witnessed something unprecedented. Judge Calloway nodded, a look of finality in his expression. He turned back to Barron, his voice steady. "In that case, the testimony remains admissible. That ruling is final." Bang! The gavel's impact echoed like a gunshot. It wasn't just the end of a ruling, it was a declaration. The entire room seemed to exhale at once, as if breaking free from an invisible hold. But Barron, he simply gathered his notes with the same quiet precision he had displayed from the beginning. There was no victory smirk, no self-congratulatory glance, just a calm, methodical process as he straightened the edges of his legal brief and prepared to leave. But before he could step away, Judge Calloway cleared his throat. "Mr. Trump," he said, halting him in his tracks. Barron turned back, waiting. The judge studied him for a long moment, then leaned forward slightly. "I've been on this bench for a long time," he said, his voice carrying the weight of years spent overseeing countless legal battles. "I've seen seasoned attorneys walk through those doors, thinking they could outmaneuver the law with confidence alone." He paused. "Most of them fail." A slight shift ran through the crowd. The attorneys seated behind Holloway exchanged knowing glances. The journalists leaned in. This wasn't just a judge's reflection, this was an admission. "But you," Calloway continued, tapping a finger on the bench, "you didn't rely on theatrics. You didn't stall for time. You didn't throw around legal jargon just to sound impressive." He let the words settle before finishing. "You knew exactly what you were doing." Barron remained composed, but for the first time something in his posture shifted. He hadn't expected the compliment. The judge tilted his head slightly. "Tell me something, son. How long have you been studying law?" Barron didn't hesitate. "For years, Your Honor." Calloway raised an eyebrow. "And yet you're not in law school?" A pause. Then, with quiet certainty, Barron replied, "Not yet." A quiet chuckle spread through a few corners of the room. Not mocking, but impressed. Calloway exhaled sharply through his nose, shaking his head. "Well, I'll tell you this," he gestured toward the opposing counsel's table. "If half the attorneys in my courtroom prepared like you did, my job would be a hell of a lot easier." Holloway sat stiffly, arms crossed, his mouth a firm line. There was no point in arguing. He had lost, and everyone in the room knew it. Judge Calloway straightened his posture and adjusted his glasses. "The ruling stands. Court is adjourned." Bang! The gavel struck once more, sealing the moment. As Barron Trump walked out of the courtroom, the energy in the room had shifted. What had started as a spectacle, a privileged young man expected to stumble, had transformed into something entirely unexpected. He had entered as the son of a former president, but he was leaving as a formidable legal mind in his own right. Behind him, Judge Richard Calloway remained seated, his fingers still tapping lightly against the bench. He watched Barron with an expression that was no longer dismissive but contemplative. He had spent decades presiding over cases, encountering attorneys who relied on posturing and theatrics to make up for a lack of preparation. But this young man, he hadn't needed tricks. He had walked in ready, and he had left nothing to chance. Across the room, Martin Holloway, the veteran attorney who had once exuded confidence, sat motionless, his jaw clenched, his hands resting on his closed folder. He had been bested, not by an experienced litigator, not by a high-powered legal team, but by an 18-year-old who had outmaneuvered him at every turn. The gallery, once filled with smirks and whispered amusement, now hummed with quiet discussions. Legal analysts exchanged glances, journalists rewrote their headlines, and even rival attorneys found themselves reevaluating their assumptions. But Barron? He paid no attention to the murmurs. He walked out with the same steady, composed demeanor he had carried throughout the entire trial. No arrogance, No outward celebration, just quiet certainty. He had known from the start how this would end. Outside the courthouse, the media swarmed. Flashbulbs exploded, microphones were thrust forward, and reporters fired questions from all directions. "Mr. Trump, were you nervous? How did you prepare for this case? What's next for you in the legal world?" But Barron didn't slow down. He didn't need to answer. His arguments had spoken for themselves, and his actions had made a statement louder than any words ever could. The lesson was clear. Real power doesn't come from a name. It comes from knowledge, preparation, and execution under pressure. And today, Barron Trump had shown the world that he was more than just a name. He was a force to be reckoned with. What do you think? Would you have expected Barron Trump to hold his own in court? Drop a comment below and let's discuss. And don't forget, if you enjoyed this story, hit that like button and subscribe for more inspiring content like this.